Delivering this week's must-watch workplace storylines, this is Bloomberg Law's Punching In, for those of you listening in Washington and across the globe.
Hey folks, thanks for punching in with us. In our first item today, my colleague Robert Iafolla will be joining me. Hey Robert, how are you?
Doing well, thanks.
So my understanding is you have a piece coming out tomorrow on Tuesday that will be looking at the effects of the infamous joint employer rule, which is about when two businesses are both the legal employers of a group of workers. Tell us a bit more about the piece.
Yeah, so in 2015, the Obama Labor Board made it easier for companies to be held liable for labor law violations committed by their subcontractors, staffing firms they work with, other companies that provide them with contract workers, and maybe more importantly, in the unionization context, it can force these bigger companies to the bargaining table to deal with unions representing those contract workers.
Right. And that was, of course, the issue. My own coverage of the joint employer issue was mostly about franchising, right? That industry there has said that the joint employer rule that's currently in place is actually a threat to the entire model of a franchise business. And so, I put the word, when I said effects, I said that quite broadly. But what question are you actually trying to answer here?
Yeah, so employer groups have been really critical of the expanded joint employer test from day one. They said it's too vague, they've said it's unworkable, that it can mess up all of these business-to-business arrangements, especially in franchising, like you mentioned. So what I'm doing is I'm taking a look at how often NLRB judges and regional directors have actually decided joint employment cases using this expanded test that employers say they hate.
Right. That's interesting. And obviously, I'm sure you're still working and you're probably on deadline, Robert. I understand how that goes. But what are you finding so far as a conclusion with the data?
Yeah, still looking at it, but so far it looks like this expanded test has been used less often than you might think.
All right, great. We'll definitely follow up with you tomorrow to see the exact answers to the questions here. And thanks for joining us, Robert.
Thank you.
In our next item today marks the first day of a planned 3-day strike at the LA ports. And what's going on there is a group of warehouse workers and truck drivers trying to put pressure on logistics and shipping companies called XPO Logistics and NFI Industries to pay them back pay they claim they're owed. Now, those companies have very big clients like Amazon, that's one of the world's top 2 biggest retailers, and Toyota and Puma. Toyota's obviously also one of the world's largest auto retailers. And they're trying to put pressure on those businesses who aren't actually their employers, and they're going to be picketing and distributing leaflets at the warehouses, retail outlets, and headquarters of their employers' clients like Amazon and others, as I've said. Now, the workers aren't actually in a union, but they're being led by the Teamsters Union, and they've put on about 15 of these kinds of actions in recent years. The central issue here is about joint employment again. Folks who are down a supply chain who sort of claim that an employer up or a business up the supply chain has some control over their working conditions and so therefore is responsible for some of those working conditions. And a quote here from one of the truck drivers makes this particularly salient. And here's what he says: "At the end of the day, we work for them too." He's referring there to Amazon and Toyota, etc. "We carry their cargo, so we want them to support us." So now these workers will be carrying out these actions over the next 3 days. And one interesting wrinkle here is the Labor Board recently issued a decision, and I'll have a report later this week on that decision. But what they ruled in that case, this was a similar situation where a group of workers had held a strike. It's known as a secondary picketing, right? These workers are striking and not necessarily targeting just their own employer, but they're saying a business their employer has a relationship with should also have some say and some responsibility for their working conditions. Now, the Labor Board said based on these workers' signage and their targeting of that business that wasn't their employer up the supply chain kind of crossed them over into unlawful secondary picketing. Now, the set of facts here in the port workers case might turn out to be different based on their signage and their wording and what they say their goals are, et cetera, et cetera. But that decision nonetheless could be applied in this case. So it'll definitely be interesting, and we'll keep an eye on that and let you know what's going on with the strike over the next 3 days, as well as sort of the legal analysis of how these workers are putting on their action. In our last item today, my colleague Chris Opfer recently talked with Labor Secretary Acosta, and part of that conversation went to worker training. Now, the central driving force there is automation and information technology, right? Workers will inevitably be displaced by the advancement of automation and companies that are sort of based on apps and code and infotech, if you will. So one strategy to deal with that economic job loss hit is to retrain those folks so they do have the skill sets that translates to information technology and robots, et cetera, et cetera. What Acosta addressed with Chris is that, no one's really talking about who's going to pick up the tab to retrain those folks. And he suggested that you could incentivize businesses so they can sort of actually pick up the tab for this and offer training to workers who get displaced. And also to look at ways to stop other businesses from acting as free riders and not paying for their own workers retraining, but sort of sitting back and waiting for other bigger corporations to retrain workers so they can sort of benefit from that more skilled talent base in the workforce there. So Chris will have more on that conversation in the column, so be sure to follow that. All right, that's it for this week, folks. Thanks for punching in with us for the Labor Desk's Monday Morning Musings. For more coverage, be sure to check out our website where the Punching In column is hosted. That's news.bloomberglaw.com. And of course, you can always follow me on Twitter at Hassan Kanu. See you next week.